This
I'm
is
on my feet just to answer your question about the terms of the bill
yes,
that was before Parliament in 1996
Yes.
as compared to the Act.
yes.
And sections 40, 41 and 42 were the same in the bill as in the 1996 Act.
At the time, it was being
So,
considered
when the
by
DAC
the DAC.
report, yes, exactly, they were commenting on the wording which is the wording in the Act,
Thank you.
but it was a form of a bill at that time.
Thank you.
Just one other tiny point on that point. On the question of 41A and how you read the Act, the law in our submission is that the court construes the Act as a whole. When you're asking yourself, what does Section 40 mean? What does Section 41 mean? You construe the Act as a whole. And the Act's an Act of Parliament, matter of first principles, always speaking. It's not kind of preserved in aspect in 1996. So you do have to construe sections 40 to 42 with 41A now being in there. Whatever that takes, how much help you get from that, you can't just ignore it because it wasn't around.
Well, there's quite a lot of authority which I've seen over the adjournment about the extent to which you can use amending provisions to interpret the other sections of the Act, which doesn't all speak with one voice, but the latest Court of Authorities seem to say you can, but only in cases where it's genuinely ambiguous.
Of course,
But
neither side, for diametrically opposed reasons, suggests there's anything ambiguous in Section 40.
no, you both say it's clear in your own favour, but
Yes, exactly. Elusively so.
all right.
Can I come back to my Lord Justice Phillips' point, which I'm afraid I've rather garbled before the short adjournment about Section 41(1). I've already, in answer to my Lord Justice Popplewell's point on 41(5), I've already made the submission that 41(1) does not qualify or constrain 41(5). It just doesn't as a matter of language. But the point in answer to my Lord's observation before the short adjournment was this: if you look at the words of 41(1), the parties are free to agree on the powers of the tribunal in the case of a party's failure to do something necessary for the proper and expeditious conduct of the arbitration. Now, that language obviously reflects Section 40, the preceding section. So if there's been a failure to do something necessary for the proper and expeditious conduct of the arbitration, that must necessarily be a breach of the duty of the parties of one of the parties in Section 40, subsection 1. So even if, contrary to my first point, 41(1) somehow informs 41(5), which it doesn't, but even if it did, you're still forced back to Section 40 because it's 41(1). It is by definition a breach of Section 40. Then you get to Section 40, when that, of course, is really the terminus of the case. And on my Leonard's friend's case, well, let's take my case first. Any order means any order, my submission.
In 42A.
In 42A, that's right. Mr. Dunning's submission is that any order, and so any order has to be complied with, and that's part and parcel of the proper and expeditious conduct of the proceedings. That's my primary simple submission. Mr. Dunning wants to say that any order is itself qualified, has to be looked at through the prism of whether the order itself is somehow necessary for the proper and expeditious conduct of the proceedings. So he tries to get the defining characteristic of Section 40 from 41, but he's looking in the wrong place, because the definition, which applies then in 41(5) of order. So when you look then at 41(5), if without showing sufficient cause, a party fails to comply with any order or directions of the tribunal may make a peremptory order to the same effect. And those words obviously hark back to 42A, which in an inclusive way defines the duty to do all things necessary for the proper and expeditious conduct of the proceedings as a duty to comply with any order or directions of the tribunal. It's really as simple as that. And the other point to make on Section 40 is that Section 40 is the concomitant duty on the parties. It's the late Lord Justice Laws have said it marches in step with Section 33, which is a duty on the tribunal. And we looked briefly at Section 33 this morning, but Section 33, subsection 2, you will recall, says the tribunal shall comply with that general duty, which is set out in 33(1) of acting impartially and adopting procedures suitable to the circumstances and so on, in conducting the arbitral proceedings, comma, in its decisions on matters of procedure and evidence, and in the exercise of all other powers conferred on it. Those are three different things, that the comma and the and make it clear that these are three concepts and not just somehow one concept. There are three things going on. And section 40, as I say, is the concomitant duty imposed on the parties to comply, to do all things necessary for the proper and expeditious conduct of the arbitral proceedings. And that includes complying with any order. Now, one of the other points that my Lord Justice Popplewell asked before the short adjournment was this difficult question of the red shoes or the green hair or whatever, whether what happens if the tribunal makes an order which seems to be, as it were, irrational. We did make some submissions to Mr Justice Butcher on this, and you'll find his analysis of it in his judgment at paragraphs 59 and 60. But just before I come to that, can I just say that, in my words, what the learned judge is saying. He essentially refers to guidance from Mr Justice Tier in a case called Emmett and Michael Wilson, which he sets out, and he treats it as a question of discretion. So as I submitted before the short adjournment, if we get, well, we'll see what...
I think that may be because it appeared to have been conceded by Mr Millet below, because when Mr Millet was dealing with the question as to whether this was a valid order within Article 28, he himself submitted that only went to the question of discretion under Section 42.
Well, he was right about that.
If we look at the second half of paragraph 36,
he was right about that.
Mr Millet did not contend that even if the tribunal did not have power to make an order, that would necessarily preclude the court from making an order under Section 42.
Yes.
So it doesn't. Mr Justice Butcher didn't have to address the point.
Well, maybe not, but to the extent that he does, it's at paragraphs 59 and 60 of his judgment. So, can I then? So I hope that deals with 41.5 and 41.1 and 41 and 42A, which are also the constituent elements. So if we just look at 42A, there is no qualification, obviously, of the phrase any order or directions. And it's an obvious point, but if Parliament had wanted to qualify the type of order with which parties had to comply, the obvious way to do it would be to put words in 42A, when you're not to put in the broadest possible words, which are any order, but to say some orders or describe what the orders were. But it doesn't do that. It's any order. And as I said before, short adjournment, I wasn't going to show you all of the cases we've dug out in my learned junior's research, but I do want to show you what Lord Bingham says in the Jackson case, which is at Authorities Bundle 1, Tab 1, page 158. It starts at 138. I don't think we need to look at the head note unless anyone particularly wants me to. But the whole of paragraph 29 is important. On the third line, the Attorney General invites the House to focus on the language of the 1911 Act, and in this he is right. It is a careful study of the statutory language, read in its statutory and historical context, and with the benefit of permissible aids to interpretation, is the essential first step in any exercise of statutory interpretation. Pausing there, Mr Dunning took you to the DAC report, and he doesn't get any help from that here, but obviously it is an admissible aid to interpretation, it just doesn't help. Here, section 2.1 makes provision, subject to 3 exceptions, for any public bill which satisfies the specified conditions to become an Act of Parliament without the consent of the Lords. And then he refers to those 3 exceptions. And then at just above F, there's a sentence beginning, subject to these exceptions. Section 2.1 applies to any public bill. I cannot think of any broader expression the draftsman could have used, nor can I see any reason to infer that any is used in the sense other than its colloquial and also its dictionary sense of no matter which or what. And we respectfully adopt that, and that's the approach which the court should take in relation to 42A here. Any order means any order, no matter which or what. The expression is repeatedly used in this sense in the 1911 Act, and would be surprising if used in any other sense. And then he gives some examples. And last sentence, any is an expression used to indicate that the user does not intend to discriminate or does not intend to discriminate save to such extent as is indicated. And that's a statement of principle, bang on point, which we respectfully invite your lordships to and your ladyship to follow here. There are other cases where the House of Lords of the Supreme Court has said the same thing, but Lord Bingham, with his usual clarity, sets it out there, and none of the other cases improve on paragraph 29 of Lord Bingham. The next case I want to show you again briefly is a case called Spillers in Cardiff, which is a Authorities Bundle 1, tab 1, page 34. It's a very long case, and it took me a while to work out what was going on. It's actually a case. It's an appeal by way of case stated from a number of I think magistrates and courts. It's Lord Hewitt, the Chief Justice, with whom the rest of the court agreed, says at the marked passage, it ought to be the rule, and we are glad to think that it is the rule, that words are used in an Act of Parliament correctly and exactly, and not loosely and inexactly. Upon those who assert that that rule has been broken, the burden of establishing that difference is by heavy, and they can discharge it only by pointing to something in the context which goes to show that loose and inexact meaning must be preferred. And then finally, in this part of the argument, I want to show you briefly the Assange case, which is at Authorities Bundle 1, tab 1, page 289. And this is Lord Phillips, who was one of the 3-2 majority in this case. I think it's Baroness Hale and Lord Nash dissenting, but Lord Phillips was in the majority. And it's the obvious point that when considering the meaning of a word or phrase that's used more than once in the same instrument, one starts with the presumption that it bears the same meaning wherever it appears. That is not, however, an irrebuttable presumption. It depends upon the nature of the word or phrase in question and the context in which it appears in the instrument. And then he goes on to discuss the framework decision there. Well, here, the word we are concerned with is any. And it's, as Lord Bingham says, it's the broadest possible formulation of word that one can imagine. I cannot think of any broader expression the draftsman could have used. So the word any we've set out in the skeleton argument at paragraph 50, a number of other cases where that word appears throughout the 1996 Act, and I'm not going to take time by going to it, but in particular section 6A.4 defines legislation to include any provision of a legislative character and treaty to include any international agreement. And section 49, a tribunal may award simple or compound interest on the extending amount of any award. And in all of those cases, one can apply Lord Bingham's formulation of no matter which or what, which is what any means. So my case is really very simple, that the words any order or directions of the tribunal mean what they say. To the extent that one needs to look at dictionaries or look at authorities, we have Lord Bingham telling us what any means in the legal context. And there's simply no basis for a more restrictive statutory interpretation, which would involve reading into the text words which Parliament didn't put in, and would do it in a way which would lead to the slightly, well, more than slightly, curious consequences that Mr Dunning accepts as the logic of his argument in terms of what the court's got power to do and what the tribunal's power to do. If the tribunal's got power to make an anti-suit injunction or anti-arbitration order, which Mr Dunning accepts that it does, and Article 28 makes it clear that there's power to make anti-suit orders under the ICC rules, why on earth shouldn't it be able to take steps to seek to ensure that its order is complied with? And the Act provides for the peremptory order regime. There's no good reason why, if the tribunal, if it's accepted, a tribunal has got power to make a procedural order, direction X, dealing with subject Y. Why should somehow there be some types of order which can't then be taken further to the peremptory order stage? It's hard to think of a reason. There's no reason explained anywhere in the Act. It's not in any of the materials that can be used to construe the Act, and that's because it's simply not there.
Why does the court need that power if it has power under Section 37 anyway? Well,
the difference with Section 42 is that, of course, the court's got, as it were, overarching power under Section 37 of the Senior Courts Act to do lots of things and to give injunctions of different types and so on. But what's different about Section 42 is that there's been an order of the tribunal which hasn't been complied with. And the tribunal then has statutory, the tribunal's then got the power, or maybe have the power conferred on it, to make a peremptory order. And the point about the court's function is that the court is then, at Section 42, enforcing the peremptory order, and it's doing so in a way which recognises that there's been a breach of the tribunal's order. It's the fact that we're dealing here with broken orders that makes a difference, and that's why Section 42 is different conceptually from the Section 44 regime that Lord Mance was concerned with in his case. True it is that in that case, in the paragraph which I'll come to, 46, 47 and 48 of Lord Mance in that case, true it is that there's consideration as to whether Section 37 and Section 44 can exist coterminously, or whether one ousts the other in circumstances where there is an arbitration on foot. Now, those weren't, of course, the facts of that case, because there was no arbitration. The only available route, therefore, was Section 37, because there was no arbitration on foot on the facts of that case. But obviously, in this case, there is an arbitration on foot. The arbitration has been going for a couple of years. The arbitrators have obviously been making orders in the course of that arbitration, as they naturally would. And when they're breached, they're entitled to make a peremptory order, and when that happens, if they give us permission, we're entitled to come here. So we're squarely in Section 42 territory here. We're not in Section 37 territory, although if for some reason that submission is wrong, and Mr Justice Butcher didn't think it was wrong, and it's not wrong, but the court does have the safety net power under Section 37 to make exactly the same order as Mr Justice Butcher did under Section 42, and that's why when Mr Millett, I think it was, raised the question of Section 37 in advance of the hearing before Mr Justice Butcher, our position was, we don't need this, we've never needed this, this is a Section 42 case, but we applied for, ahead of the hearing, not at the end of after the judgment, we applied before the hearing for permission to add Section 37. Mr Justice Butcher acceded to that. He didn't deal with it in his judgment. When he then gave permission to appeal here, of course, that then brought into sharper focus the fact that he hadn't dealt with Section 37, which he might have done, but he didn't. There was then some correspondence with the judge about whether he should then do so at that stage, and he declined to do that. It's now suggested against me that we should be appealing against Mr Justice Butcher's refusal to reopen his judgment, but that's, with respect, a silly point. That's not right. What we're doing is what Mr Justice Butcher expressly recognised and contemplated we might do, which was to take our Section 37 point here by way of respondent's notice and rely on it in the alternative if it's necessary. And that's my position, and we'll have to develop that if necessary when we come to Section 37.
Presumably the reason why one can't find an example of section 42 having been used for an anti-suit injunction is that parties use section 37,
They do usually, yes, that's right. That's right.
which is absolutely commonplace, certainly in
Yes.
my experience.
Yes. Well, in this case, originally there was an application made against two other parties, and then by the time we got before Mr. Justice Butcher, there had been a settlement of the position of the parent company of ECNW2. But in this case, the parties had been dealing with the tribunal. The tribunal had been making endless procedural orders, Mondays, Wednesdays and Fridays, because of the breaches that were going on after Mr. Justice Bright's judgment. The tribunal was very anxious that its arbitration shouldn't be knocked off course, and it seemed to it's a straightforward application of the statutory regime to go section 40 procedural order, peremptory order, and come to the court under section 42. Your lordship's quite right that in many cases, when this arises, often the other party will be seeking to steal a march. I mean, it's very unusual for parties to be consensually arbitrating in London pursuant to their agreement they made many moons ago. They're happily arbitrating for a couple of years. But what happened here, of course, was that when Mr. Justice Bright's judgment came out, the other side realised the writing was in fairly large capitals on the wall. So they then, at that stage, start proceedings abroad. Now, usually, of course, if the party wants to behave badly and breach its arbitration agreement, it will usually take preemptive action in some foreign forum. It won't come to arbitrate in London for 2 years and then disappear somewhere else. And in those circumstances, which will be the usual circumstances where there's foreign proceedings, whether it's an arbitration or litigation, in those circumstances, of course, the party who's seeking to enforce the arbitration agreement will come to court under section 37, and that's entirely consistent with what Lord Mance says in the AES case. So these are very unusual facts. I don't know whether your lordship's been in an arbitration where the parties have been happily arbitrating for 2 years and then somebody suddenly starts messing around with other fora later. I haven't, and it doesn't matter what my experience is, but it's a very unusual state of circumstances, which
Well,
mean
about 2 years, but it's not uncommon for parties who have started an arbitration to seek an anti-suit injunction.
It's clear that I think in the past there was some debate about whether one could come to court under section 44. We had the settle in jurisprudence, and Mr. Dunning's shown you some of that, and the direction of travel of the courts over a series of decisions over a number of years has been progressively to say, if the arbitrators have got power, you shop there. That's and to restrict the circumstances in which the court will entertain parties to an arbitration coming to court to get an order from the court. And so over time, there are going to be more cases, one would have thought, where the parties in the position of my clients here are using the peremptory order, section 42, at root where appropriate, rather than running off to court under either section 44 or indeed section 37.
Might it be said in opposition to a section 37 application that the question as to whether there should be anti-suit relief depends upon whether there's been a breach of the arbitration agreement, and that is something which the parties have exclusively agreed to treat as something exclusively to be decided by their chosen arbitral tribunal?
Well, that's if I may say so, exactly why, when considering which route was to be applicable in a case like this, one might conclude that the obvious starting point is to look at what the parties have agreed, the powers they've conferred on the tribunal. The tribunal then addresses questions of compliance with the parties' bargain. And as I say, the statutory regime then leads one to section 42 when the arbitrators give permission. So yes, it could. The answer to your question is yes, Lord. That could be an objection, and that's why Mr. Justice Butcher, who was clearly obviously Mr Justice Butcher himself's got great experience in arbitration and in granting injunctions of all sorts on the bench, and he had no difficulty at all in concluding that Section 42 was the appropriate route, and he didn't deal with Section 37, but he once or twice mused as to whether it was would be an alternative.
But when he refused to reopen, one of his reasons was there has been a Section 42 order, and the tribunal have been seized of the dispute as to whether there should or shouldn't be an anti-suit injunction, and that of itself rendered it inappropriate for him to exercise a jurisdiction on an alternative basis because it wasn't necessary. So I'm not suggesting he decided that would always be an answer, but he obviously had that in mind.
Yes, well, it's never been my case that I need Section 37. It's always been my case that Section 42 is the correct statutory provision, and it's
Well, I understand that, but it's also your case that if you're wrong about that, Section 37 is available, and it's Mr Dunning's case that we shouldn't worry about Section 42 being unavailable. For Section 37 is available, so but all right, he's mouthing potentially available, which may suggest that this is a point he might want to keep up his sleeve.
Yeah, well, he did put it a little more broadly earlier. I wrote that down actually. Well, my primary case. I don't need Section 37, and the point your lordship just made, I see the force of, but nonetheless, that's my alternative safety net in case I fall off the wire on the first point. I think we need to labour the point that under the rules, because the court's got this point well in mind, your lordship's already referred to it 2 or 3 times, that there's no doubt that the arbitral tribunal had power to make an anti-suit injunction. Mr Dunning accepts that. That's your lordship's stage 1. Articles 28 and 29 of the ICC rules deal with that. We've mentioned it in our skeleton. Article 29 provides for emergency arbitrators to deal with urgent interim or conservatory measures that cannot await the constitution of an arbitral tribunal, and Article 28 confers the power on the tribunal.
But Article 29 wasn't directly applicable in this case.
I'm sorry?
Was it? Article 29 wasn't applicable
No, it wasn't.
in this case.
No. It's Article 28.
Yes.
Article 28.
You're just drawing attention to the fact that emergency arbitrators would have had the same power.
Yes, exactly. And so you would, in this situation where, on Mr Dunning's analysis, the emergency arbitrators process has got more legs and more teeth than the process of the ordinary tribunal, which, as I say, would be curious. Can I then go to Pearl Petroleum, which is at AB 22383, Authorities Bundle 2, Tab 2, page 383. Now, can we just go back? Can we go back to page 372, please? And this is the case where, because of the way Mr Dunning now wants to explain it away, I do want to show you the head note here, just so that the court understands what the case was about. It may be that you're familiar with the facts. Can we just have it so I can see the whole page? Thank you. So what happened was that there was a dispute about the claimant's rights in relation to gas fields. You see that from the second paragraph. And the claimants were saying they were entitled to $1.1 billion. And in March 2014, the claimants applied to the tribunal for an order granting interim measures, and the tribunal used its powers under the LCIA rules and ordered payments under the contract of 100 million, which was 70% of the invoices. And that was to maintain the status quo pending the outcome of the arbitration. There was no compliance, and application was made to the tribunal under section 41(5) for a peremptory order, and the tribunal ordered that payment was to be made within 30 days, and then that wasn't complied with. So then, with permission of the arbitrators, the matter came before the commercial court under section 42, and the application was contested on 2 grounds. First, that the peremptory order had been made improperly, and secondly, the court had no jurisdiction by virtue of section 14 of the State Immunity Act 1978. And the learned judge, Mr Justice Burton, held, and this is 1B of the head note, there was a power to make a peremptory order, although under section 40, an order could be made only in respect of the proper and expeditious conduct of an arbitration, and the arbitrators did not spell out a reference to the proper and expeditious conduct of the arbitration. They clearly concluded it was appropriate that the status quo ante, whereby PRG paid for what was lifted, should be restored, and that was necessary for Dana in particular to be able to continue with the arbitration. This was not an order on the basis of an assessment of the eventual outcome, but of a return to the status quo irrespective of the outcome. No need for the arbitrator to spell out such words, nor a need for the court to be astute to construe detailed reasons such as were given here given by the arbitrators in the context of assuming that experienced arbitrators were in some way failing to comply with their duty. So that was the decision. If we then go to page 382, now Mr Dunning took you to this earlier. So the argument, so there's a heading, section 42 of the Act. Mr Pollock's case was short and simple, like mine is here. Mr Dunning's was more elaborate, like it is here, and his argument is dealt with from paragraphs 18 through to 24. And if we go over then to 24, and the critical passage for my purposes is, although all of 24 is important, but 24.4 on the right-hand side, as is clear from section 41.5, referred to above, it provides for the making of a peremptory order where there's a failure by a party to comply with any, emphasised, as is the judges, any order or directions of the tribunal. Mr Dunning sought to point to section 41.1 as giving context, but that ignores section 40, upon which he relies for these arguments, the general duty of parties. Section 40 requires such parties to do all things necessary, etc. But that's then explained in terms in section 42, namely that this includes complying with any order of the tribunal. My underline that analysis. That's my case. That's good analysis. It's sound law. Obviously, it's not binding on this court, but it's correct, and the court should follow it. And in Hashwani, just very briefly, Hashwani, Authorities Bundle 1, tab 1, page 237. And this is a Supreme Court case, but Lord Clark, with whom 3 other members of the court agreed, paragraph 41, the arbitrator is in critical respects independent of the parties. Its functions and duties require him to rise above the partisan interests of the parties and not to act in or so as to follow the particular interests of either party. As the ICC puts it, he must determine how to resolve their competing interests. He is in effect a quasi-judicial adjudicator. In England, his role is spelled out in the Arbitration Act 1996. By section 33, he has a duty to act fairly and impartially as between the parties and to adopt procedures suitable for the circumstances of the particular case, so as to provide a fair means of determination of the issues between the parties. So pausing there, like my Lord Justice Popplewell this morning, Lord Clark is going back, first of all, in the analysis, before we get to what the parties have got to do, we go back to what the powers of the tribunal are. Section 34 provides that subject to the right of the parties to agree any matter, it's for the arbitrator to decide all procedural matters. Examples of the width of those powers can be seen in the particular examples in 34, subsection 2. Section 40 provides the parties shall do all things necessary for the proper and expeditious conduct of the arbitration, which includes complying with any order of the arbitrator, whether procedural or otherwise. So on. So there's no hint of any suggestion of any qualification, such as or qualifying words, such as Mr Dunning urges on the court. It's true, of course, as Mr Dunning said, that this case wasn't concerned with anti-suit relief. Well, so what? Because Mr Dunning accepts. I'm not quite sure. Mr Dunning kept referring at times to the anti-suit relief point, but he accepts. Ultimately, he accepts that the tribunal has got power to grant anti-suit relief, and he accepts that they did so, and he accepts that was a valid order. So it's not clear to me, no doubt I'm missing something. It's not clear to me where that point really takes him, because the question is whether there's some qualificatory words which mean that any order means only some orders, and he would have to show some words which carved out anti-suit relief or anti-arbitration relief, and they're just not there. That the words just aren't in the Act at all. As far as Mr. G is concerned, well, his textbook is just, and of course, textbooks are textbooks, but it's not an authority, it's not binding on this court, but it's obviously a textbook that is well consulted and well respected, and the view he gives is my submission correct. I just want to show you a little bit, one more case, I think, on the question of the Act, which is Authorities Bundle 2, tab 2, page 518. This is a can we go back to the first page of this? I'm sorry, I haven't got the reference for that, but it can't be very many pages back. I'm sorry. I'm very grateful. 514. So it's Mrs. Justice Carr as she then was, and if we then go back to 518, paragraph 19. Having set out section 42, paragraph 18, the power in section 42 to enforce peremptory orders is part of a set of complementary statutory provisions in the Arbitration Act 1996. And again, notably, in the next breath, she goes to section 33, which is really the start of the analysis of this group of sections in the Act. Section 33(1)(b) provides for the tribunal's duty to adopt procedures and to avoid unnecessary delay or expense, so as to provide a fair means of resolving the dispute. 42A provides for the parties' general duty to comply with an order of the tribunal. 41(5) provides for the tribunal's power to impose a peremptory order in the event of the party's non-compliance. She might have added with any such order. And section 41(7) sets out the tribunal's range of sanctions in the event of a party's non-compliance with a peremptory order. So 33, 42A, 41(5), which are the critical sections for our purposes. No mention of 41(1) being some sort of qualification on 41(5). And then she goes on, Mrs. Justice Carr goes on, the terms of section 42, can we see the next page as well, make it clear the court's at discretion as to whether or not to grant an order under section 42. And then she sets out this familiar guidance from Mr. Justice Tier in Emmett and Michael Williams. It's the same passage that Mr. Justice Butcher dealt with, where Mr. Justice Tier says the purpose of section 42 is to expose a non-compliant party to an order for contempt if he breaches the court order. The proper role of the court is to support the arbitral process rather than review the tribunal's exercise of its power to issue peremptory orders. Whilst the court should not act as a rubber stamp on tribunal orders, it is not necessary for the court in every case to satisfy itself that orders ought to have been made, in a sense that the court must review the tribunal's decision. In general terms, the court might decide not to make an order if the party comply when such an order is not required in the interest of justice to assist the functioning of the arbitral process, for example, because of the material change of circumstances since the peremptory order was made, or whether the tribunal can be seen not to have acted fairly or impartially. And I think in one of the cases, I think it was Mr. Justice Burton's case, he refers to them being a de minimis threshold. It's not every order that would necessarily be the subject of a peremptory order. It's not every peremptory order that would get permission to come to the court under section 42, and it's not in every case at section 42 that the court will make an order. One can think of any sensible tribunal would give permission to come to court under section 42 unless one's dealing with a serious breach of an important order, because everybody knows that section 42 potentially ends up with contempt proceedings if the order is not complied with. And everybody knows that that's to be a step to be taken in serious cases. But jurisdictionally, the circumstances in which one can end up before the court in section 42 are very, very broad. I'm not going to take you to the textbooks which we set out in the skeleton argument. Mr. Dunning did that, and I'm not going to take up time with that. Can I then go to Lord Mann's in the AES case, which is at tab 2, page 367. And we should just go back to the heading. It starts at page 350 before we get to 48, which I'll come to. I don't know if the court has the facts of this case in mind, but there was a hydroelectric facilities in Kazakhstan. There are many hydroelectric facilities in Kazakhstan, which was much to the benefit of the English bar recently. The agreement was governed by the Kazakh law, but contained an arbitration clause providing for arbitration in London under English law. In proceedings related to the concession, the Supreme Court in Kazakhstan held the arbitration clause was contrary to public policy and thus invalid. Then the successor in title to the owner which had entered the agreement brought proceedings in another court in Kazakhstan. That court allowed the claim to proceed. The claimant continued to deny the jurisdiction of the Kazakh court, but defended the merits of the claim, since unless it did so under Kazakh law, it was precluded from appealing the court's decision on jurisdiction. The claimant, who had not commenced arbitration proceedings and had no intention or wish to do so, commenced proceedings in England for a declaration as to the validity of the arbitration clause, and obtained without notice an anti-suit injunction in respect of the Kazakh court. Then there was then a challenge to the English court's jurisdiction to entertain those proceedings, and the judge held that where there was no actual or intended arbitration, an injunction could not be granted under section 44, but there was jurisdiction to grant an injunction under section 37 of the Senior Courts Act. The court had jurisdiction to give permission for service of the claim out to jurisdiction and so on. I don't think I need to read that. And if we go over the page, please. Sorry, can we go, sorry, my fault. Can we go back to paragraph? Yes, that's it, thank you. The Court of Appeal dismissed the defendant's appeal, and the matter came before the Supreme Court. And the relevant part of the headnote is at page 351 between C and D. English courts had a long-standing and well-recognised jurisdiction to enforce a negative obligation by restraining foreign proceedings brought in violation of an arbitration agreement, even when arbitration proceedings had neither been commenced nor were being contemplated. And under section 37 of the Senior Courts Act, the court had power to directly or enforceable by penalties for contempt against the commencement or continuation of foreign proceedings brought in breach of either an arbitration agreement or an exclusive choice of court clause. And that power was not affected by anything in the Arbitration Act 1996. And that's the ratio, that's the relevant part of the ratio in my submission. And section 42 and peremptory orders, of course, weren't under consideration at all in this case, because by definition there was no arbitration at all. We then go to paragraph 48, which is the high water mark of my learned friends' authorities argument. We go to paragraph 48, which is at page 367. So there have been, as you saw this morning, there have been competing views. There was Mr. Justice Cook and there was Mr. Justice Coleman's decision. Lord Mann said the better view, in my opinion, is that the reference in section 44(2)(e) to the granting of an interim injunction is not intended either to exclude the court's general power to act under section 37 of the 1981 Act in circumstances outside the scope of section 44 of the 1996 Act, or to duplicate part of the general power contained in section 37. And again, that's the ratio. I've got no difficulty with that at all. It doesn't impact on my case whatsoever. Where an injunction is sought to restrain foreign proceedings in breach of an arbitration agreement, whether on an interim or a final basis, and whether at a time when arbitral proceedings are or are not on foot or proposed, the source of the power to grant such an injunction is to be found not in section 44, but in section 37 of the 1981 Act. Such an injunction is not for the purpose of and in relation to arbitral proceedings, but for the purposes of in relation to the negative promise contained in the arbitration agreement. But of course, none of that's got anything to do with section 42, which is about the court enforcing the peremptory order of the arbitrators. And Lord Mann's simply doesn't deal with it. So the case is clearly distinguishable from our case, and the ratio of the case is that expressed in the first sentence of paragraph 48. In any event, the words in section 44, which is what Lord Mance was considering as to whether section 44(2)(e) in particular, the words in section 44 are different from the words in section 40. And we make the point in the skeleton argument that when Parliament uses different words in two sections not very far apart in an act, it must be dealing with different things and using those words carefully and correctly and differently. So
it's difficult to see that the words in section 44 are narrower than necessary for the problem.
It's not obvious that that's right. That I can see conveniently why it's forensically convenient for Mr Dunning to suggest that. They're just different in my submission. For the purposes of and in relation to arbitral proceedings, section 44, I don't accept that the words are broader and that Mr Dunning's a fortiori point works. The words are just different. They're dealing with different things. And in any event, the critical definition for our purposes is not in 40 subsection 1, but in 40 subsection 2a, any order. So I don't accept that you can simply take what Lord Mance says about section 44(2)(e) and transpose it to the context of peremptory orders in section 42 and say, oh well, the language of section 44 was in some sense broader. So a fortiori, that's the answer. I don't accept that analysis at all. But the words are simply different, dealing with different things. So the real point of distinction is that in this case, the court's not merely doesn't simply have an application to enforce the negative obligation not to commence foreign proceedings, but to give effect to the positive obligation of the party to comply with orders of the tribunal. That's what section 42 is about. That's why we're here. So it's not merely the negative obligation, because once an arbitration is on foot, and once a tribunal has made orders and directions, they've got to be complied with. That's where the general duty of the parties in subsection 41, section 40, subsection 1 comes into play. And so it can't simply be shrugged off as being all about the negative obligation. There's a positive obligation to comply with orders of the tribunal, and that's why this case is completely different from AES. So, and yes, and on the broader point, the words in section 44 were for the purposes of and in relation to arbitral proceedings. And if anything, those words are they're more restrictive, they're more tailored. Purposes of the arbitration, as opposed to in section 40.
Necessary for the conduct of the arbitration.
The conduct of the arbitration. And one can see that the conduct of the arbitration can be discombobulated by, for example, an order of a foreign court ordering one party to stop. That affects the conduct of the arbitration. Whether it's for the purposes of the arbitration, often it will be. No doubt, often it could be. But conduct is, if anything, a broader concept in my submission than purposes. But in any event, the words are clearly different. And that case is clearly different. And nothing in its ratio affects my case. And in any event, we keep coming back to any orders. We make the point in the skeleton that Mr Dunning referred to this morning that Mr Justice Butcher, in his judgment, has held that an order restraining his clients from seeking to litigate its arbitral claims in the Russian courts and preventing it from seeking in Russia to injunct my clients from continuing the arbitration is an order which can properly be said to be necessary for the proper and expeditious conduct of the arbitral proceedings. So in any event, the judge has concluded that that's the position, and so did the tribunal. So it's not open in my submission to Mr Dunning now to take issue with that. His argument's got to be one of as it were, pure principle. So, please bear with me, my lord, when I switch to the note from this morning. Yeah, so Mr Dunning's argument in the end comes down to section 40, subsection 1, and saying that orders only have to be complied with if those orders are themselves, in some sense, necessary for the proper conduct of the arbitration. But he's got it back to front, because what section 40 does is to provide that any order of the tribunal must be complied with. Imposes that is part of the duty, the general duty of the parties set out in the first subsection. And quite a lot of the points that he makes about the particular order might affect the discretion of this court to make an order under section 42, and I accept that the court won't always make an order under section 42. The court's clearly got power, as Mr Justice Tier explained in Emmett and Michael Wilson, in certain circumstances not to do so, but in this case there's no reason not to do so. Yes, couple of tiny points before I finish. My Lord Justice Popplewell asked me about the adding up of paragraph 5 of the skeleton. I should have also mentioned the fact, or shown or directed your attention to the previous paragraph, paragraph 4 of my skeleton argument. So paragraph 5 is dealing with the penalties, which there are three different things going on in Russia. There are substantive proceedings, which are a replica of their counterclaim in the arbitration. Then there were interim measures in one of those proceedings, and then there's the anti-arbitration orders as well. Paragraph 5 are the penalties which apply if we don't comply with the anti-arbitration provision.
Yes.
But over the short adjournment, I was instructed that no. Oh, okay, all right. So no, it's wrong. Okay. So we know that an order's been made, and so those penalties are potentially coming down the line. But paragraph 4 is dealing with a separate amount of money, $2.19 billion US, and judgment's been entered against us in the substantive Russian proceedings. And I mean, there's a lot going on. These are clearly very aggressive and sophisticated litigants, and I mean, there's lots going on. For example, as we understand it, according to Mr Melnichenko, who is the director of the Appellant's immediate parent company, in his witness statement in the court below, that MCC, which is the parent company of my learned friend's client, is in the process of divesting the Appellant to an entity called Minerals Fertiliser Production EuroChem LLC, an entity about which we know nothing. So there's obviously a lot going on, but for our purposes today, it's really quite short and simple. Can I just check with those behind me whether there's any other matters I need to deal with? Unless I can help the court any further at this stage, that's all I want to say.
Thank you. Mr Dunning.
Yes, my lord. Thank you. I just not very much to say, but a few points. Could I start, please, with looking at section 41 in my learned friend made some submissions about that. And we have this in tab 28 in volume 3 of the authorities at page 801. And just taking the provisions, the relevant provisions in order, section 41, subsection 1, the parties are free to agree on the powers of the tribunal in the case of a party's failure to do something necessary for the proper and expeditious conduct of the arbitration. And the sideline, I know we're not supposed to use that for interpretation, but it says powers of the tribunal in case of parties default. Then it says, unless otherwise agreed, the following provisions apply. Now that, in my submission, must mean, unless otherwise agreed by the parties as to what is to happen in the event of a party's failure to do something necessary for the proper and expeditious conduct of the arbitration. In other words, you read in the words from subsection 1 into subsection 2. The following provisions apply in relation to such failure. Section 41.2 is not untethered from subsection 1. It is to be read in light of. You can agree what's to happen in the event of a failure to do something necessary for the proper and expeditious conduct of the arbitration. But if you don't, then these provisions apply to something which is necessary for the proper and expeditious conduct of the arbitration. And then subsection 3 deals with delay. Subsection 4 deals with failure to make submissions either orally or in writing. And subsection 5 is the one with which we are concerned. And so when we come to subsection 5, it says, and bearing in mind that the whole of section 41 is, the subject matter is the powers of the tribunal in the case of a party's failure to do something necessary for the proper or and expeditious conduct of the arbitration. If without showing sufficient cause, a party fails to comply with any order or directions of the tribunal, that is clearly subject to the introduction in section 41 and section 41.2, that this is all in relation to a party's failure to do something necessary for the proper and expeditious conduct of the arbitration. And then, subject to reading it in that way, the tribunal may make a peremptory order to the same effect. So then when we come to section 42, it says, unless otherwise agreed, the parties may make an order, the court may make an order requiring a party to comply with a peremptory order made by the tribunal. That refers back to section 41.5, which itself is subject to section 41.2, and that is to be interpreted in the light of section 41.1. So those are my submissions in relation to section 41.
Forgive me, all that 41.1 is doing is dealing with a situation of default, where a party has failed to do something necessary for the proper and expeditious conduct. And then when you go back to see what the content of that, you find that from 40 subsection 1, this includes complying with an order or directions of the tribunal. So you do not get from the route you have taken us through to anything further about what is an order or directions of the tribunal other than appears in 40 subsection 2a.
Well, I mean, that takes, and you're right to take us back to section 40, but section 40 also starts with the parties shall do all things necessary for the proper and expeditious conduct of the arbitral proceedings. So there's the qualification that this is the subject matter of section 40, and section 41 starts with a similar qualification. And I was simply trying to explain to you why under section 41 I submit, where that concept is carried through into section 41, why section 41.2 must mean, in effect, unless otherwise agreed by the parties in relation to a failure to do something necessary for the proper and expeditious conduct of the arbitration, the following provisions apply to such failure, because that's effectively what it's saying. It's not, it's the connection between section 41, section 41.1 and sections 41, 3, 4, 5, 6, and 7. And it's saying that where there's been a failure to do something necessary for the proper and expeditious conduct of the arbitration, then these provisions apply. And those provisions, therefore, the application of those provisions in subsections 3, 4, 5, and 6 and 7 all presuppose that there has been a failure to do something necessary for the proper and expeditious conduct of the arbitration. That's my submission. Now, then, when we are interpreting that phrase, I'm not going to take you back to the case, but we've just looked at paragraph 48 in the AES decision of the Supreme Court, where the Supreme Court held that an anti-suit injunction is not for the purposes of and in relation to arbitral proceedings because it is enforcing the negative covenant in an arbitration agreement. And therefore, the Supreme Court said the applicant is not without remedy, but he must go, she must go, or it must go to section 37 seeking relief. And what we are saying in relation to section 42 is exactly the same. We're saying that the reasoning applies a fortiori in light of the qualifying words, something necessary for the proper and expeditious conduct of the arbitration. The applicant is not without remedy. They must go and seek their remedy under section 37. And it's as simple as that.
But do you say?
Well, can I finish? And because then you might.
You know what I'm
might
going,
be about to.
You know
ask
what
you
I'm
this.
going to ask. Yes.
Well, I was going to. You put to me, my lord, that there were multiple hurdles in my way, and in my respectful submission, there is only one hurdle, and that is: am I right to submit that there's no power to grant a court order, a court injunction under section 42, because, as I say, as a matter of law, an anti-suit order made by the tribunal is not necessary for the proper and expeditious conduct of the arbitration within the meaning of sections 40 and 41, and hence the relevant peremptory order is not a qualifying peremptory order under section 42. That's the only hurdle I have to cross. If I'm right about that, I don't have to cross any further hurdles.
I understand that, but there are three answers to that, each of which you have to surmount. The first is section 41.5 isn't limited by 41.1. The second is, if it is, 42A tells you that any order, breach of any order, is itself a failure to do something necessary for the proper and expeditious conduct of the arbitration. And stage 3 is, if you've got this far and you've knocked those two out, that an anti-suit injunction and an anti-arbitration injunction can never be properly characterised as something necessary for the proper and expeditious conduct of the arbitration, even if one posited, for example, a case in which having to fight on the foreign front meant that the claimant simply couldn't afford to pursue the arbitration, even if being subjected to the foreign anti-arbitration proceedings meant he had to stop.
Yeah. Well,
so whether one describes them as separate hurdles or whatever, they are all arguments that you need to meet in order to go from A to B, although you express A to B in a single step.
Well, I've just addressed you as to why I submit that the qualifying words, something necessary for the proper and expeditious conduct of the arbitration, are read into section 41.
Yeah, I think you have addressed all three. It's just that reformulating it as a single test may not mean you don't have to engage with all three.
I didn't have to make that point, and I've just made that point. But subject to that, the question is, as a matter of law, in light of the reasoning of the Supreme Court, where one is seeking to enforce the negative covenant in an arbitration agreement, is that something which, as a matter of law, is not necessary for the proper and expeditious conduct of the arbitration because it is the enforcement of the negative covenant in the arbitration agreement, which is the reasoning of the Supreme Court. And that doesn't mean you're without relief. It just means, as in the AES case, you go to section 37.
I understand that.
And
When I paused, I was actually going to ask you something different rather than.
okay, I'm sorry.
But do finish the point you were making, and then I'll come back to it.
And so we say the court, it is open. It was open for them to seek relief under section 37. There may have been separate arguments to be raised in relation to that, but they elected not to do so. And I don't know whether your lordships have had the opportunity of reading our supplemental skeleton, but there is a very curious history, which my learned friend skated over quite quickly here. If we could just look quickly, please, at that supplemental skeleton.
Well, before we look at
I'm not going
section
to
37, but can I ask you my question?
Okay, fine. Yeah.
Which is, you say no problem about all this because there's a remedy under section 37. I put to Mr McLean, well, might it not be said in answer to an application under section 37 where there is an arbitration on foot? Well, that involves matters that are exclusively within what you have agreed to refer, and you shouldn't be asking the court to decide whether the foreign proceedings would breach the arbitration proceedings. And I had thought you wanted to leave open the ability to say that, but tell me if you don't.
Well, I'm not making any submissions. I think I did say, I certainly intended to say this morning that it would be available to them to seek relief under section 37. I'm not conceding for a moment that they get relief.
No. But doesn't
to follow.
But whilst you make that reservation,
yeah,
you can't at the same time say there's no need for any section 42. Because section 37 necessarily provides an absolute answer.
No, I'm not. But I'm not saying there's no need for section 42. I'm saying there's no jurisdiction to grant for.
I know you are, but part of your submission was we needn't worry about that because in all cases you'll just be able to go under section 37. So there's no lacuna, as I think it was put at one stage.
There is no lacuna. I'm not. I mean, bear in mind, my submissions are not really focused on the facts of this case. They are high-level submissions about what a person can do in this situation.
No, but should I write down that you reserve the position to this extent that a party might have a valid answer to a section 37 application based on it being a matter that ought to be referred to the tribunal? Is that a fair reflection of your stance?
Yes, but they can certainly, and as my Lord Justice Phillips said, they can certainly come to the court and they can say the arbitrators have made decisions here that they haven't got the power to enforce those, and we'd like the court to make its own injunction, so that there is a process of enforcement available to the parties. Now, whether the court will decide to make that will depend on all the circumstances. And as I think I read out this morning, the passage in AES, which refers to Lord Mustall's statement in the Channel Tunnel case, which is that the section 37 injunction itself is not to enforce the arbitration agreement, but one where the arbitration agreement forms part of the background, whether it's just and equitable in all the circumstances to grant an injunction. And equally, under section 37, if there's been orders made by the tribunal and those have not been complied with, those would form part of the background, which the court would take into account. But
so if I can just understand your position, if the party went straight to court seeking anti-suit relief under section 37, it might be an objection to that they hadn't gone to the tribunal first.
Yes.
But if they go to the tribunal and they get the tribunal to make an order and make that determination, and the tribunal makes a peremptory order, they've got to rely on section 37 rather than section 42.
Well,
I mean, where's the sense in that?
Well, you might say, where's the sense in the decision of the Supreme Court? But that's what
I wouldn't
the
dream
Supreme
of ever
Court
saying
decided. they decided that enforcing the negative covenant in an arbitration agreement is not for the purposes of and in relation to a reference. It's enforcement of the negative covenant in the arbitration agreement, and that has to be done under Section 37. Now, and that's what I'm relying upon, because I say it applies equally or a fortiori in relation to the relevant qualifying phrases in Section 41 and 40. And this, as my Lord Justice Phillips said, may explain why there hasn't been a case in nearly 28 years trying to use Section 42 to get an anti-suit injunction. Certainly, it's common ground now that there hasn't been such a case. And could I just, in terms of the history of this particular case, and I'm not going to take you through all the documents, but we've set it out very clearly in our supplemental skeleton. So let me just take you to that. It's you'll find that in the bundle.
Are we straying into the other aspect of the
Well, only
argument
for
now?
the history. Only for the history. I'm not going to argue the legal points.
But how's the history going to help us? Because
Well, because my point is that
sorry, can I just
Yeah.
make my point first?
Yeah. Okay,
Your
sorry.
argument doesn't depend upon the facts of this case. Your argument is that this is so as a matter of law,
Yeah.
and would be so irrespective of how anybody had behaved in relation to
Yeah, no,
Section
fine.
37, and indeed irrespective of the particular anti-suit orders in this case.
Yeah.
So how does it help us to look at, for the purposes of the Section 42 argument, to look at what's happened in relation to Section
No,
37?
it doesn't really. It doesn't really. And my point is simply that the appropriate route is to apply under Section 37, not under Section 42. And there's a curious history here, paragraph 7 to 15. You can read it if you want. They elected not to take that route before the judge. The permission. My learned friend said he got permission to amend,
Yeah,
but he didn't
so
get
hold on,
permission
hold
to amend until after the judgment.
So what?
And then he applied 5 days later to reopen the matter to argue Section 37, and the judge refused.
No, not to argue. Well, as I understand it, the position was there was a formal draft amendment to the application notice seeking to rely on Section 37. It wasn't decided before the hearing started. At the end of the hearing, the question was raised, and Mr. Justice Butcher said in terms at page 151 of the transcript that he was granting permission to amend on Section 37, and that was then reflected in an order. There was then an application to reopen in which the claimants asked him to decide it on the Section 37 basis, and he said, I'm not going to do so because the tribunal is seized of it, and B, you'll be able to raise it by way of respondent's notice anyway. Now,
Yeah.
Is that a fair reflection of the history?
If your lordship has understood that when the amendment was granted, the judgment had already been given. I don't know if your lord, you said at the end of the hearing, the judgment was given.
Yes, after the judgment was given.
And then after the extemporary judgment,
Yes.
the application was made for permission to amend
Yes,
and granted.
yes.
Yeah.
As indeed it was in relation to some of the amendments which he had dealt with without formally granting permission.
Anyway, it was post-judgment. Yes, that's the only qualification of what you should say.
Anyway,
So-
as you say, that doesn't help on Section 42.
No, I only mentioned it because a learned friend talked about the amendment, and I thought
Right.
therefore you should have the full history. But if you want, I mean, essentially what you've said is correct. The paragraphs 7 to 15, I think, of the supplemental skeleton give you all the references and the detail on that.
Well, although they suggest there was never permission to amend, so they're not entirely accurate, but
No,
I
I
think
don't think we suggest that. I don't think we suggest there was no permission to amend, my lord.
But you also say it wasn't in our skeleton, that's wrong too.
It's
Anyway, it doesn't matter.
Anyway, there's an amendment order, so there was permission to amend.
yeah, well, yes.
If we inadvertently suggested that, that was a mistake. It certainly wasn't intentional.
Yeah.
My lord, unless I can help you further, I have no further submissions.
Okay, well, I think we'll rise to see where we've got to.
Court rise if able. Stealing your electricity.
I got it.
Very kind, thank you.
He will be on YouTube.
So what? Yeah, we can watch it. Send it to our friends.
Greatest hits.
Send it to friends.
This is live and there was no
No,
recording.
no, I think it's recorded.
Do a montage.
This is your first TikTok assignment.
This is the time to do it.
Court looks,
Cool.
hashtag court fit.
So, yeah, you gotta, I want some AI introduction to animate. Make everybody dance.
Mikhail dancing in the back.
The live feed catches all of us in 6-7 in the back together.
Like dying inside.
Our under concert was
That's gonna be John's goal. Is if you have this customers, you have to say 6-7 and we all.
We could monetize that video.
We could run it,
Trust me.
yeah. This will be a
New financial model. In contempt.
Yeah, we'll be content.
I'll be like, I'm like Yuri, I can't.
Just you just slowly sink.
Literally
That'd be reported.
CP
I'm
or
all on
not.
Friday.
Legal 316.
I wonder if James can hear us.
Back. Well, the microphone's just there, so probably not. I've seen. I think only approvals to send
Yeah,
skeletons.
but not like comments.
No, I mean,
It's not the best feed.
it's true.
Yeah.
Yes, and
Yeah,
like,
they do.
I mean, they weren't expecting. Miracles.
Yeah.
We'll get it before Christmas.
I mean, there's
It's
a
Christmas,
Supreme,
you never know.
there's a Supreme Court decision.
Sounds like you decided
Yeah,
that.
well, that's my thinking. Well, does it?
Taking an average of this room.
Yeah, I'd say he's second. Don't get me wrong, I'm serious first, and there's 30 people in the room.
John, is that yours? Thank you.
Court rise if able.
So what we're going to do is, we're not going to hear any further argument. We are going to announce our decision, which is that we dismiss the appeal. Therefore, we don't need to hear any more on the section 37 point. We will give our reasons in due course. You'll get them in the usual way, handed down in draft. You all know the form, typographical and administrative errors only, not an opportunity to re-argue. We always say, because it's important, the embargo must be complied with, and there's a risk of contempt proceedings if it's not. It seems to us that there ought to be an order now which reflects that decision, so that an order is drawn up saying that the appeal is dismissed. Where that leaves any other consequential aspects of an order is something that we'll hear from you on, and if you would like 5 or 10 minutes to think about it and take instructions, then we'd be content for you to do so.
Well, I'd like to accept that offer.
Yes, 10 minutes, I think.
Court rise if able.
Do you have any particular points that you'd help with other than
Costs.
costs? I mean, we'll ask for permission to appeal.
Yeah, I think that's it. I don't think so. I think that's it.
That's it. The only other point I wanted was the time frame for PTA's to the Supreme Court, should you wish it, because you'll have the order but not the judgment.
Yes, that's what I wanted to extend it until we get
So
the
the time should run from the judgment.
You might think,
Yeah, well, it'd be quite difficult to.
That's the
well, I don't know. I'm not sure.
that's the only point.
Yeah, I think so.
This is the test.
But we're going to need in the order, that provision we had in the butcher order, because obviously we can't
You won't, but
we can.
Is it CD 5? Is it CD tab 5?
Sorry.
CP 5. Yeah.
So this was But the reason for that is that they didn't want it to be debate about it. Is the obligation to pay is going to come on the basis.
Yeah, okay.
So, I'll just, so we just. Yeah.
Yeah. Where it says the name on the
So we can drop an order, just missing the appeal. Yeah?
Proceedings.
But that
Okay, cost for missing appeal. Picture with an interim payment, of course, but it's detailed assessment, right? Yes. Yeah. So Bennett, square copy. You got one? There is one. One square copy. You hold that, don't square copy. Yeah. Yeah. Yes, because if it's a big one, it's accessible.
Can I just ask, what are you asking for on costs?
Somebody assessment.
You're asking for
Somebody assessment. Both sides have got schedules.
Yeah, that's what we're doing. We just sort of work out who's doing this, given the sanctions.
Well, there's a provision in the picture order. It's the same provision as in the Mr. Justice Pictures order here, which deals with payment. Paragraph 5. It's in paragraph 5, I think it is. Yeah.
SB 337 is the reference.
SB
337.
All right.
Okay. So you guys are going to drop the order.
We'll discuss that later. Let's try and get through it first. Oh, maybe I'll give it right now.
It's only happened once.
There's only one
It's 42.5.
Leave the court, yes.
We'll take the wrong one home.
Yeah. Well, Yeah, you can see from 45. You can see from 45. Otherwise, that sentence could be out. At the end of 45.
Probably times. What do we take? 45.
We can get last about 45. So last sentence.
There you go.
So same as assume it's 44.
I see.
What? Exactly. I run a podcast. I run that number of times. It's called draft number one. It's the respondent or defendant should be breached of us. You're carrying the hard yards.
Do you have that? The court decision is hard. Decision under section 42. Join means not. That's not worried. What's an advisory?
I'm a big fan.
Is the court ready?
Yes.
Okay.
Court rise if able.
My lord, question to do with on my agenda is costs. We would invite the court to make a summary assessment of the costs of this area, which is a
You'd like an order for costs first,
yes. I would like an order for costs.
right?
There are schedules from both parties. I suspect they're in supplementary. Excuse me, supplementary bundle 3. If I remember from this morning, it was actually your supplementary bundle 2. At tab 37 is our schedule,
Right.
and the other, yeah. So if you've got page 677 and 678, that's the other side's schedule, and my schedule should be either before or after it, I'm not sure which, I'm gonna number the copy.
I think it's not after, because that's the last tab I have.
It must be the, can we go to 676 and see what that says?
No.
Oh, no. Sorry? Oh, I see. Where is it in this one? It's not in, I'm told that only one of the schedules has made it into the hard copy bundle. I'm sorry about that.
Right. So which is the schedule you would like us to consider?
The one in my hand. This one, my lord. I'm sorry about the lack of pagination. So, in my submission, the appeal has been dismissed. There's no reason to depart from the general rule on costs, and I invite the court to make an order for my client to have their costs of the appeal. They schedule the grand total in this schedule. So I've only got one copy of this.
We've only got one copy of this. Thank you, Mr. Robb. That's very
I don't
helpful.
know why these weren't in the supplementary bundle, but I'm sorry, they're not. It was set up yesterday. It's not just done today. I don't know why it hasn't happened. I'm sorry. It's our fault, no doubt.
Right, we'll just pause for a minute until we've all got it.
This one is sticky. It's the same for
Okay, thank you.
So, Lord, I invite the court to make an order summarily assessed. The grand total on our schedule is £275,000 forward. The other side's grand total is 182,000 odd, so obviously mine is a good deal higher. I accept that. But this is litigation which is being fought heavily on a number of fronts, as you've seen. It's an important appeal, and quite a lot of time's been spent on it. So I invite the court to make a summary assessment in the sum in our schedule or such other figure as the court thinks fit.
Right.
Very quickly, because Mr. Robb will address the figures, and obviously we agree that the appeal should be dismissed. We don't oppose an order for the usual order for costs to follow the event. I wish to say something in a moment about permission to appeal and stay and the timing of any application to the Supreme Court.
Yes.
So far as costs are concerned, as I say, we don't oppose the usual order. And my learned friend Mr. Robb will address the quantum of the summary payment.
And you're happy to have them dealt with on a summary assessment now rather than an assessment and a payment on account?
Well, we're mindful that the court has said that it needs to stop sitting at 4 o'clock.
Well, no, I said we need to finish the argument at 4 o'clock because I anticipated that we might need a little time afterwards to deal with these sorts of matters. But
Mr. Robb will tell you, but I believe he hasn't got a huge number of points he needs to make.
Right.
So I think he can make them within the time available. We're happy to do so.
Can I just raise one other point? You'll see from Mr. Justice Butcher's order that there's a specific provision put in about the actual payment of any sums because of the sanctions position.
Yes.
Mr. Justice Butcher actually ordered detailed assessment and payment on account, but whatever way it happens, we'll have the same provision in this court's order as well. One final point, my Lord Justice Popplewell made the point earlier about the embargo of the judgment and so on. It's just been pointed out to me that this must have been live streamed today.
Yeah.
So I'm not quite sure.
No, there's no embargo on the decision, and there'll be an order. It seemed to us one of the reasons why you ought to have an order is so that it's perfectly patent that we have made a decision to dismiss the appeal. The embargo applies to the draft judgment, which gives the reasons, which you won't get immediately.
I just wanted to be absolutely sure that's
Right. Mr. Robb.
My Lord, for submissions, my ultimate submission is that the contractor's costs should be assessed at £134,000 odd, and I'll explain why. The first point is that this was our appeal, and one would expect the appellant's costs to be higher than the respondents, all the more so in circumstances where we made a stay application, and we actually had to put in two skeletons, one a supplementary skeleton responding to their respondent status, yet their costs are 50% higher than ours. That invites scrutiny as to why their costs should be so much higher than ours. So my second point is that that 50% disparity is partly a function of NWS's very high hourly rates. The court can see from the schedule, partners at £1,250 per hour, senior associates at £1,005 per hour, junior associates at £745 per hour, and trainees at £375 per hour. And those may be compared with the guideline hourly rates found in volume 1 of the White Book at page 1446. It might be convenient if I just read them out. So this is for London 1, which is very heavy commercial and corporate work by centrally based London firms. So even at that level, 2025 rates of £566 for grade A, £385 for grade B, £299 per hour for grade C, and £205 per hour for grade D. So there is a vast disparity there, and there's no reason to think that the contractors could not have had their application and this appeal proficiently conducted by solicitors charging the guideline hourly rates, which after all are already for very heavy commercial and corporate work by centrally based London firms. And if NWS's fees are reduced to the guideline hourly rates for London 1, then that would reduce the £130,000 on figure in the schedule down to £54,434. And we invite the court to make that reduction. There's no reason why costs should be recovered in excess of London 1. Now, I anticipate the point will be said against us well. Collins Botty at Command Instruction Solicitors also charge an hourly rate, which is above the London hourly rates. Well, 2 points about that. 3 points. First, that's not the touchstone. The touchstone is it is the whole function of the guideline hourly rates, and the court should be assessing costs by reference to them, not by reference to the other party's costs. Second, insofar as it may be relevant, Collins Bottiot's fees have themselves been heavily discounted by application of cap. So being reduced from £114,000 odd to £60,000 odd. And even if you were to reduce NWS's fees to the Collins Bottiot level, which as I submit is not the right approach, that would imply reducing the £130,000 odd down to £83,648. So there would be a £46,000 reduction. But as I submit, we say it should be reduced down to guideline hourly rates, and the £130,000 odd should go down to £54,000 odd. My next point, and this was my third point, is that the overall disparity is partly a function of the disparity between counsel's brief fees. Briefly, the figures are my learned friend Mr McLean, King's Counsel £95,000, and my learned friend Mr Leary £50,000, as against, on our side, Johnny £69,750, Mr Millet, who worked on the skeleton argument, who did some work at the start of this appeal, £11,625. So that would be a total of £81,375 for silks fees on our side. And that's taking against us the point that we ended up having to instruct two counsel. And my brief fee was £32,750. So overall, that is £145,000 spent on counsel on the contractor's side, as compared with £114,125 on our side, which is a £30,875 difference, or a 27% difference.
Right.
And in the experience of my instructing solicitors, and cost strata that they regularly deal with, one would normally expect respondents' counsel's fees to be 30% lower than the appellant's counsel's fees, given the disparity between having to prepare an appeal and having to respond to appeal. So my submission would be that the respondent's counsel's fees should be reduced from £145,000 total down to £79,887. But if the court is not with me with that, then there should at least be a reduction.
Sorry, they should be reduced to
£79,887.
So is that on the basis that that's a sum less than yours, but
The
calculated
basis
how?
being that it should be reduced to the amount which would need to be incurred in order for the appeal to be conducted proficiently. Top of the market fees, but a reasonable amount as per the Kazagi case. And I'm inviting the court to take our fees as a starting point in having a look at what would be reasonable, but also to discount from that by 30%, bearing in mind that normally one would expect.
I see. So your 79,000 figure is 30% less than your 114,000.
That's right.
Thank you.
So my fourth submission is that £275,000, which is the total claimed by the contractors, is simply a very large amount of money for a one-day appeal based on a single ground of appeal, which required no witness evidence from the contractors, and where counsel and solicitors were already fully up to speed on the issues, both from the first instance hearing and being instructed in the arbitration. By reference, the Samsung Electronics case, which is often cited in this context in terms of guideline hourly rates, there was leading and junior counsel and a one-day appeal, costs of £72,000 were claimed, and they were reduced to £55,000. So overall, my submission is that the contractor's costs should be assessed at 130, the recoverable costs should be assessed at £134,321.50, and that is made up of £54,434 of solicitor's fees, which is NWS's fees reduced to the guideline hourly rate for London 1, plus £79,887.50 for counsel fees, which was produced by the methodology expert, looking at our fees as comparable and then reducing by 40%.
It's very clear. Thank you.
Lord, I don't want to spend very long on this, but the guideline rate point, I accept. We can all see what the guideline rates are because they're guidelines. They're not rules. Those guideline rates are often exceeded by both parties or all parties in heavy commercial litigation. But I accept those are the guidelines and that they're in the book and they must be there for a purpose. So I can't really elaborate on that any further. My learned friend's on rather shakier ground with his analysis of the 30% reduction, which depends on his giving evidence as to what his cost draftsman would usually expect, at least when they're appellants as opposed to respondents. It was an inventive argument, but in truth, the discrepancies in terms of counsel's fees are not actually all that terribly material, or they're not very far apart. It's true that they're slightly bigger on our side in this court, whereas the other side, before Mr Justice put it was the other way around. But the discrepancy in counsel's fees is not massive, but there is clearly a discrepancy. But I don't accept that the Court of Appeal should simply apply a 30% discount, which would take us to a number which is considerably lower than their own fees. But Lord, in the end, the court paints with a broad brush when it comes to costs. the court will form its own views of what the appropriate sum is, and I won't detain you any longer.
All right. Let's deal with anything else we need to do before we give you a decision on that.
Yes, well, the just other things are as follows. I'm instructed to ask for permission to appeal to the Supreme Court on this important point of principle, which has never been decided before, and pending the hearing of such appeal, a stay of execution. I'm also instructed separately, this is a separate point, I don't believe this is opposed by my learned friends, to ask for the time for applying to the Supreme Court, if you were to refuse permission to appeal, should run from the time we receive your detailed judgment on the hand-down and not from today, because if we are to formulate a point to the Supreme Court, we can't formulate that until we see.
Well, I'm not sure we have power to do that. Can you just show us that we have power to extend the time which is in the Supreme Court rules?
Right. Well, this was suggested to me by the junior on the other side. So
usual course is that you don't move your application until you've got the reasons.
Sorry,
we can
squeaking behind my lord. I didn't quite hear what you said.
What my lord said was that the usual course
yes.
is not to seek permission until you've seen our reasons, and we do have power to extend the time for seeking permission to appeal from us
from you
until after you have had those reasons, and it may be that means that the time doesn't start running for the Supreme Court purposes until after we've made our decision on permission to appeal, and that's how you protect your ability, should we refuse it, to be able to apply to the Supreme Court in time.
Yes, well, that makes sense. So can I ask, therefore, for an extension of time for seeking permission to appeal until we've seen the detailed judgment?
Is that opposed?
No, my lord.
So that the time will, I mean, in other words, the time will run from the date when we have the...
When the reasons are handed down, you'll then have 28 days.
Yes, thank you. And apart from that, we asked for a stay, or I'm instructed to ask for a stay.
So a stay pending any application for permission to appeal.
Yes.
And both Mr. Justice Butcher and Justice Mayles refused to stay on the basis that you'd made it clear, your clients had made it clear that they weren't going to comply with the order anyway. Is there anything you want to say about that?
Well done. Obviously oppose the stay for the same reasons that we did before Mr. Justice Butcher and Lord Justice Mayles.
All right, thank you. Anything else before we retire to decide those points? No.
Court rise if able.
doesn't want it back, but they give it to me, so I'm due to it, but it's not mine, it's his.
That's how it is.
Yeah, I mean, I think they're going to extend after.
Yeah.
Supreme Court.
Someone jumping out of this. Sorry, and it was just in his speech. I just lost about 3 or 4 words. I just. And then costs. Yes.
Sarcasm doesn't work with transcripts.
You just said we've had that. Well, then, we're in a bit of debate, aren't they? So you're doing the arbitration judgments.
No, I'm not actually.
Somebody said you were.
I don't know actually. I think there was.
I'm sorry, I know. I think maybe I said that. I thought I thought that was.
I think there was one time I think the possibility that might.
Okay, well, my apologies.
I think it's doing all right, but it sounds like it's yes, I think that's the best. I guess that happens. I don't think it's the first time people have wow when sitting.
Because everyone turns around.
Everybody ready?
60 seconds. 60.
Interesting.
Decision in as well.
Court rise if able.
So the order will be, the appeal is dismissed, appellants to pay the respondents' costs of the appeal. We will assess those costs summarily at the amount of £180,000, 180,000. That's a reflection of the fact that we see a good deal of merit in the points that Mr. Robb has made about the hourly rates and council's fees. And we've chosen a figure which essentially is one which we think is overall proportionate. So far as a stay is concerned, we will refuse a stay for the same reasons as Mr Justice Butcher and Lord Justice Nails, namely that the appellants have made it clear that they don't intend to abide by the order of the court. We will extend the time for the appellant to seek permission to appeal from this court under CPR 52.3b to 28 days after we have handed down our reasons for the decision which we have announced today. Could you please draw all that up in an order? The costs will have the same rubric in relation to the dealing with the sanctions regime. Could you send it through, please, to the clerk, to Lord Justice Phillips? I don't have a clerk who will be available tomorrow, and she'll be able to deal with it. Anything else? No, well, thank you all very much. And
Court rise if able.